everybody would probably have to be living under a little bit of a rock right now to not know that we are in the middle of some financial distress. The failure of banks like Signature Bank, Silvergate Bank, and Valley Bank, they may have a significant impact on restructuring activities and economic failures. These banks play a crucial role in providing financing and credit to businesses, particularly startups and technology companies that rely heavily on external funding. If any of these banks were to fail, it could lead to a decrease in the availability of credit funding, making it more difficult for businesses to access the capital they need to operate and to grow. This could lead to an increase in restructuring activities as businesses try to adapt to the changing economic conditions. That little blurb that I just read you was written by ChatGPT. I read it to you because we live in a world that touches many other industries, but we are glad that you are here today to get an understanding of the restructuring world from the experts and not from ChatGPT. In a world where we have all kinds of access to information on the internet, I think sometimes it's easy to just throw it into a Google search, a ChatGPT search, but you don't always get the most reliable information when you go that way. So I would encourage you to reach out to experts. As I said, I think you would have to be living under a little bit of a rock to not know that we are in a bit of financial distress right now in the market. Just to give you a couple of statistics, this is as of June 23rd of this year. 2023 has tallied 218 large Chapter 11 cases. That's up 24% from the 2016 to 2022 average year to date. This case count is also up 93% from 2022 and up 50% from 2021. So we are definitely seeing a significant uptake in entities that are utilizing financial restructuring and in particular bankruptcy to restructure their debt. Over the year to date, we are seeing most filings actually in the real estate sector, followed very closely by healthcare. In Texas, we're seeing that Houston, which is the Southern District of Texas, has overtaken the total number of Chapter 11 filings in the United States. They made up on average 19% of the filings from 2017 to 2019. This year, it's jumped to 37%. 2023, the first half, the Southern District of Texas, 37% was 2022. The first half of the year, Southern District of Texas had nearly 60% of all cases that were filed. So this is a very significant jump. And I think the last statistic that I'll give you before we sort of jump into our format here is for all cases with more than $1 billion in liability, Texas hosted 12 of 17 of those. That's a big deal. That's a significant number. So what does that mean for us and what are we seeing? I think what it means is that every business, regardless of what industry you're in, regardless of your fiscal health, you're going to be touched by contract counterparties, by business counterparties who are within the restructuring sphere. And so it becomes important that you as business people, and that you as in-house lawyers are able to understand, I think, on a very big picture level, sort of what are the bankruptcy basics. So we're going to walk through kind of some bankruptcy basics, some areas that it might touch your industry and might touch on your sector. So with that, Rachel, can we turn it over to you to start by walking us over sort of the key bankruptcy basics when we talk about Chapter 7 versus 11 versus this new kind of subchapter 5 thing that we're hearing in the industry these days?
Yeah, thank you. So the bankruptcy code has different chapters that apply to different types of debtors and with respect to different types of cases. As Sarah said, today we're focused on business bankruptcies, which takes us to Chapter 7 and Chapter 11 of the bankruptcy code. A Chapter 7 bankruptcy case means the debtor company will liquidate and not emerge as a going concern from bankruptcy. So it's the end of the road for this kind of debtor. Once a Chapter 7 petition is filed by the company, the management will no longer be in control of the company, and a trustee, usually from a set panel, will be appointed to liquidate the company and facilitate the payment of claims. On the other end of the spectrum is a Chapter 11 bankruptcy case, where most often the company proposes a plan the bankruptcy court will confirm, and the company emerges from bankruptcy with a continuing business. Typically, during a Chapter 11 bankruptcy case, the debtor's management remains in charge of the company and its business. The overarching goal of a Chapter 11 bankruptcy case is to maximize value. These are the cases that you typically hear about and are typically on the news. They're the JCPenney's, the Neiman Marcus's, the Toys R Us, Circuit Cities. But smaller companies also file Chapter 11 cases. And that takes us to Subchapter 5 of Chapter 11, which provides a path for small businesses to reorganize that is less expensive than traditional Chapter 11 cases and has fewer requirements for confirmation of a plan, and creditors have less influence over the confirmation process. In a Subchapter 5 case, a trustee is appointed and tasked with facilitating the development and confirmation of a consensual plan and overseeing the debtor's operations, but the debtor's management team remains in control of the business and the company. The CARES Act, passed in March of 2020 to deal with the COVID-19 pandemic, raised the debt limit for eligibility to elect to have a Subchapter 5 case from about 2.8 million to 7.5 million, which greatly increased the number of companies eligible to use Subchapter 5. And this increased debt limit was extended by law until June 2024. Subchapter 5 was created in 2019, and Texas has one of the heaviest, busiest Subchapter 5 caseloads of any state. You all are most likely to see your customers, counterparties, vendors, etc., in a traditional Chapter 11 bankruptcy case. And so our presentation is focused on that type of bankruptcy case.
Thank you, Rachel. So Zach, could you talk a little bit for the group about what are some of the objectives of the restructuring process and what some of the benefits are?
Sure. Thanks, Aaron. Happy to be here today with you all. So when we're looking at a restructuring, the problem is that there's too much liabilities, and the causes of that financial distress are myriad. It can be, secular decline of the industry. It could be the macro environment, as we saw during the COVID-19 period, or it could be supply chain disruption or any other host of different factors that could negatively impact a company's financials. And those liabilities can come in many different forms. It can be, financial debt, so third-party funded debt that a company has on its balance sheet. It could be legacy liabilities like labor claims or environmental claims, or as we've seen in the recent past, mass tort contexts such as Purdue Pharma and Mallinckrodt. Or it could be the company is facing a ton of litigation claims that are not necessarily mass tort, but they have a lot of judgments against them or other litigation risks that they want to address in a single forum. And so while there's a number of non-bankruptcy, and by non-bankruptcy, non-Chapter 11 tools available to companies to address those liabilities, under state law, such as foreclosures or ABCs, Chapter 11 really is the most comprehensive tool that a company has. The main benefit that the companies have is once you file a Chapter 11 case, there's an automatic stay. So all efforts to collect judgments against the company, to enforce claims against the company are permanently halted during the course of the bankruptcy. This gives the debtor a breathing spell to, try to address its liabilities in a comprehensive fashion. So in bankruptcy law, it gives debtors a comprehensive statutory scheme to address those liabilities in a manner that is, over time, I think everyone recognizes is generally a fair result. There's priorities for certain creditors. There's other creditors don't benefit from such priorities, but in all, it's meant to provide a centralized forum to address different interests of creditors and, provide a debtor the rehabilitation that it may need through financial distress.
One of the things that Zach mentioned as far as state court possibilities or collection actions, is an ABC. And we're starting to see this pop up more and more. The case law is really pretty well developed actually in the state of California around ABCs. It's an assignment for the benefit of creditors. And the thing that I think is important to remember if you find yourself faced with someone that is within your business sphere who has initiated an assignment for the benefit of creditors, all of those things that Zach just walked through, the benefit of the automatic stay, the fresh start because you get the discharge, those things don't exist with an assignment for the benefit of creditors. So what you'll oftentimes hear, what we've heard as clients have come to us and have said, you know, we've got this new animal, because it is relatively new, is that they were told it's like bankruptcy light, or it's like the state version of bankruptcy. So I flag that for you, because if you hear that, I would really encourage you to reach out to somebody who has worked with these assignment of benefits of creditors before, so that you can understand really what the differences are. Because as Zach said, really the suite of things that are offered inside of a bankruptcy are more comprehensive, and provide the debtor with more protections. Conversely, it might make it a little harder for you to navigate as a non-debtor party. And you might be able to do some things inside of an ABC that you couldn't do inside of a Chapter 11. So with that, you know, Rachel, sometimes we hear that this bankruptcy process, it can be really, really long. People may remember Boy Scouts filed, they were in bankruptcy for a very, very long time. And you can kind of compare and contrast that to the JCPenney's and the Neiman Marcus's of the world who were filed and were in and out relatively quickly. Can you talk a little bit about sort of what the different timelines are for an in-court bankruptcy restructuring?
Yeah, and this is something people are very interested in because typically they want to get in and out of the bankruptcy court. So a company can enter Chapter 11 in different ways. There's a prepackaged case, which means the company and its creditors have already agreed to the company's plan of reorganization, and the company has already solicited the creditor's approval of the plan before it even starts the bankruptcy case. In this kind of case, the consenting creditors are the only creditors whose claims are not getting paid in full, typically under the plan, and all of the creditors get paid 100 cents on the dollar. Prepackaged cases usually effectuate a balance sheet restructuring versus an operational restructuring, so just getting rid of debt, like Zach talked about earlier. And the company uses the bankruptcy case as a means to shed debt with a lower consent threshold than is required in an out-of-court scenario. This is the quickest filing, meaning the company is in and out of Chapter 11, typically within 30 to 60 days, but some prepackaged cases have been days or even hours. A next step up, a little bit of a longer case, is a prearranged or pre-negotiated case, which means the company comes to an agreement with the fulcrum creditors on the terms of a plan, but the company has not solicited those creditors' approval of the plan before commencing the bankruptcy case. Prearranged cases typically effectuate a balance sheet restructuring, and the company can cut off some legacy liabilities, such as onerous contracts or above market leases. Here, the company is usually in and out in 60 to 90 days. We also have a free fall case, which means the company commences a bankruptcy case without any agreement with its creditors, and all negotiations on its exit strategy take place within the case. This is typically the longest and most expensive kind of Chapter 11 case, but it can address all of the company's issues, that comprehensive solution Zach was talking about. And it typically takes 12 to 18 months for the company to exit. We also have a 363 sale case. 363 refers to the relevant bankruptcy code provision laying out the rules for bankruptcy sales. Here, the timeline from entry to exit is typically 3 to 6 months and varies largely based on what kind of marketing process was done before the case and what your exit strategy out of Chapter 11 is going to be after the sale.
Thank you. So there's a lot of players, and a lot of times when people pick up the phone and call, the first words I usually hear when somebody calls me, regardless of what chapter they're in, is, tell me what the trustee can do. And that is always a little bit of a raising of the antenna for me, because there's a lot of different trustees actually in connection with Chapter 11 versus a Chapter 7. And sometimes those terms and the players can get a little bit confusing. Zach, can you walk us through sort of who the key players are?
Sure. So in Chapter 11, one of the benefits of Chapter 11 versus other insolvency proceedings, and this is also in the international context as well, is that the debtor, the company, once it files for bankruptcy, it has the ability to remain in possession of its assets. So it will continue managing the business after it's filed for Chapter 11. And in that circumstance, it's called the debtor in possession. Creditors can petition to have a Chapter 11 trustee to take over the management of the debtor. But that's, I would say that's the rare occurrence, at least in our practice. So you have a constellation of characters around the debtor in possession. You have various creditors. Those creditors can be, it may be that the debtor has one significant trade creditor, and that trade creditor could have a large amount outstanding as of the filing of the bankruptcy. So it may have its own counsel, or you could have financial creditors who form ad hoc committees. These are just committees of creditors that have joint share counsel and act jointly through the bankruptcy proceedings, as they typically share a common interest in terms of their interest in the bankruptcy. You of course have and of those creditors, they can of course be unsecured creditors, they can be secured creditors, they can be official committees as well. The bankruptcy code provides under the statutory framework for what's called an official committee. Typically, these are official committees of unsecured creditors, and they are fiduciary bodies that act as so-called watchdogs on the debtor during the Chapter 11 cases. So the bankruptcy code gives them significant rights to investigate the debtor's operations, to stay informed and stay in consultation with management during the bankruptcy case. And the bankruptcy courts provide a lot of deference to official committees given their statutory role. You could have post-petition financing providers. So of course, when a company files for bankruptcy, it's usually the case that they don't have significant liquidity to allow them to afford the expense of Chapter 11. So they will often look for providers of additional financing to help them navigate through Chapter 11. And those DIP lenders, typically they're from the existing creditor body, because that's the most natural place to find someone who's willing to lend to you while you're in bankruptcy. But they can of course be third-party unaffiliated lenders as well. You also have the U.S. trustee, which is a division of the Department of Justice. They're tasked with ensuring compliance with the bankruptcy code and kind of acting as the U.S. government's watchdog over the proceedings as well. And they serve, in some respects, a similar function to the official committees, but also have their own specific issues that they focus on. And of course, the most important, other than the debtor, is the bankruptcy court. So bankruptcy judges are not Article 3 judges. They're judges appointed under the, actually, I think it's legislative branch. Yeah, it's an Article 2 judge. And they serve 14-year terms. Different districts select them in different manners, but usually they are drawn from the bankruptcy bar, highly experienced in bankruptcies, and all they do day in and day out is work on bankruptcy cases, whether it's Chapter 11, Chapter 7, or the individual consumer bankruptcy cases. And they obviously have a significant amount of discretion in how the bankruptcy case plays out.
Thank you, Zach. So a lot of what we've talked about so far really is focused on the company that's in distress. But we don't expect that most of you, or if any of you on the phone, will find yourself in that situation. What we think is probably far more likely is that you will find yourself in a situation where you will be interacting with a party in good faith. Maybe they'll be a supplier, maybe you will be a supplier to them, and you'll wake up one morning to a notice of bankruptcy or an email that says, "Dear valued partner, we are writing to inform you that we have filed for Chapter 11, which of course causes the question, what do we do? How do we interact with them? How does this change? Rachel, can you talk a little bit about what the some general areas that we need to be aware of, and then maybe we'll delve into some specifics after that?
Yeah, so first off, a foundational principle of bankruptcy law is that it generally respects non-bankruptcy entitlements, meaning the statutory, contract, and other rights that parties have when the bankruptcy law doesn't apply. So for example, when a company files a Chapter 11 case, an estate is created of all the debtor's property interests, which property interests are determined by state law. The bankruptcy code does not expand or decrease the estate. But the bankruptcy code does give debtors rights that they would not have outside of the bankruptcy case. And one of the principal benefits of bankruptcy is the automatic stay, which Zach touched on earlier. The automatic stay means that creditors are prohibited from attempting to collect on their claims that predate the filing of the bankruptcy case and are prohibited from trying to take possession of a debtor's property. So if you have a secured claim against a company, after the company commenced the bankruptcy case, you can't just go in and foreclose on the property without relief from the bankruptcy court. The bankruptcy code, through the automatic stay, also provides a mechanism for debtors to enforce contracts against counterparties, even if filing a bankruptcy case is a breach of that contract. Those provisions that provide a counterparty with a termination right upon the other party's bankruptcy, insolvency, or financial condition are called ipso facto clauses, and these provisions are typically not enforceable against a debtor. Finally, the bankruptcy code allows a debtor to do certain things that it could not otherwise do outside of bankruptcy without unanimous or near unanimous consent of its creditors. I mentioned earlier that debtors can use the bankruptcy code to accomplish a restructuring at a lower threshold than would otherwise be required of an out-of-court restructuring. And by that, I mean the terms of credit agreement might require 100% of the lenders to agree to change certain terms of that credit agreement in order for that change to become effective. The bankruptcy code only requires 66 2/3 in amount and 1/2 in number of claimants that actually vote in a particular class on a plan to vote in favor of that plan for such a change to become effective. Beyond that, however, is the concept of cram down with respect to an entire class that votes against a plan. If the debtor has satisfied all of the other requirements of the bankruptcy code and another class that's not getting 100 cents on the dollar votes in favor of the plan, then the plan can be crammed down. It can be made effective upon dissenting classes and confirmed by the court. Cram down is often used in a plan where junior claims or equity interests are eliminated by the plan. Those are a couple of the boxes that we have on the screen.
Thank you, Rachel. So one of the things that Rachel touched on was ipso facto clauses and what can be enforced within a contract. I think one of the most common places that we see a filing from another entity touch on the non-filing entity relates to what we call in our world executory contracts. So I'm going to give you the very law school countryman's definition of an executory contract, which most of you probably remember. But an executory contract is a contract where there remains material obligations on both sides of the contract. What does that mean? It means that if a contract has been largely completed, all of the work is done, and say, for example, all that remains is an obligation of one party to indemnify the other party, that contract is likely not executory. And when I think about these, I think about them like sort of on a spectrum, right? The fewer things that remain, the less likely it is that it's executory. The more things that remain, the more likely it is that it's executory. So a contract where the contract is, I've contracted with Rachel that I'm going to provide her with widgets, and in exchange, she's going to pay for the widgets. I have not yet provided the widgets. She has not yet paid me for the widgets. That is clearly within the bucket of executory contracts. So why does that matter? In our world, it matters a lot, actually. One of the most powerful tools in the toolbox for a debtor and debtor in possession is the ability to assume and assign a contract, or the ability to reject a contract. It is also important because regardless, and we'll use my example of me providing widgets to Rachel, regardless of whether Rachel has performed under the contract, If I file for bankruptcy, I can compel her, if I have performed, I can compel her to continue to perform on a post-filing basis. So it doesn't matter if I'm behind on my payments, I can still compel continued performance while I'm determining if I'm going to assume or reject the contract, as long as I've made payments for services post-filing. So I use the word assumption. You see the words assumption and assignment up on the board. Rachel, can you talk for a little bit about assumption and sort of some of the really powerful things about assumption?
Yeah. So kind of as they're previewed, there are 3 different options for the disposition of executory contracts and unexpired leases. I'm going to talk about assumption and assumption assignment, and then turn it over to Zach for rejection. And with respect to each option, the debtor must assume and assign or reject the full contract. The debtor can't take a piece or a portion that it likes and get rid of the rest. So assumption of a contract means that the debtor keeps a contract and cures all defaults, as well as provides adequate assurance of future performance under the contract. Curing puts the executory contract back in the same position as if the bankruptcy filing never happened. For example, in the lease context, the cure requirement applies to tenants' pre-assumption defaults on obligations to pay rent, taxes, utilities, etc. And bankruptcy courts look to the terms of the agreement to determine what needs to be cured. For example, if there's not an express right in the lease to recover attorney's fees, then the court may rule that those are not part of the cure. Adequate assurance of future performance and what constitutes that depends on each contract and each situation, but the debtor must demonstrate that it can cure the defaults and comply with the contract provisions going forward. The bankruptcy code sets for special rules for what constitute adequate assurance of future performance with respect to a lease of real property in a shopping center. In that case, the debtor must provide adequate assurance of, among other things, the source of rent and other consideration due under such lease, any percentage rent or rent, payment based on a sales structure or otherwise will not decline substantially. Assumption is generally subject to all provisions of the contract, meaning if there's a radius, location, use, or exclusivity provision, the assumption cannot breach such provision. And the assumption of such lease will not disrupt any tenant mix or balance in the shopping center. So then next, after assumption, we have assumption and assignment. A debtor may assign a contract or lease to a third party after 1, the debtor has assumed the contract, and 2, the assignee has provided adequate assurance of future performance, and those can happen contemporaneously. The bankruptcy code generally provides that anti-assignment provisions in a debtor's contract or lease, or terms or conditions in a contract or lease that prohibit, restrict, or condition the assignment of such contract are not enforceable. Typically, once the agreement is assumed and assigned, the debtor is no longer liable for breaches occurring after the assignment. And the heightened protections that I talked about in the assumption context, also for landlords specifically, also apply with respect to assignment.
Zach, do you want to talk a little bit about rejection? And then I want to turn to something really practical and talk about practically like sort of how does this unroll on your desk and at your organization?
Yep, of course. So for folks who don't spend day in and day out dealing with bankruptcy, I find the concept of rejection is one of those ones that folks often confuse or easily conflate with something else. So rejection in bankruptcy just means that when a debtor rejects an executory contract or an unexpired lease, it has materially breached that contract, and the non-debtor counterparty then has a general unsecured claim against the debtor for any damages caused by that material breach. And that is deemed under the bankruptcy code to be a pre-petition unsecured claim. So the confusion often is when people just hear rejection, they think, oh, the debtor decided to terminate my lease or they decided to terminate my contract. And rejection and termination are actually 2 separate concepts. I mean, oftentimes what almost usually always happens is that when a debtor rejects a lease, the landlord turns around and the property is surrendered and the lease is terminated. But they are 2 separate legal distinction concepts. So when a debtor rejects a lease, or executory contract, this is more or less the prime operational restructuring tool that a debtor has. So if you can imagine a debtor that has a huge portfolio of leases, and I mean, for recent examples, think of any of the airlines or aircraft lessors that went through bankruptcy recently. The rejection tool allows that debtor to go out to its counterparties and say, if you're not willing to agree to this concession on our lease agreement or our contract, then we're going to reject your lease or contract. And it may be the case that the reason why the debtor is threatening to reject the applicable agreement is that the terms under that agreement are above market. And so the non-debtor counterparty is faced with the choice of how easy is it to replace the revenue I get from this contract or lease versus how much more beneficial it would be if I just accept the amendment. So that this is often a key negotiating tool that a debtor has that the bankruptcy code gives those debtors. And then there's of course various nuances under this rule. What is the effect of a rejection? There could be issues about, okay, so you've materially breached my lease or materially breached my contract. What does that mean for our existing obligations under that contract or lease? In a recent example, there was, for instance, litigation in the Regal Cinemas cases where Regal, AMC, and Cinemark all have exhibitor services agreements with a screen advertising provider. That screen advertising provider gave most favored nation clause protection to AMC and Cinemark. And so when a new agreement was reached with Regal through the bankruptcy cases, the question was, does that MFN apply? Or because the contract had been rejected, and the bankruptcy court said, no, it doesn't apply. And that's now currently up on appeal before the district court, and likely will probably go to the Fifth Circuit as well. As like, what was the effect of that rejection on the clauses underneath the underlying agreements that were rejected?
Thank you, Zach. So let's talk practical. I once had a bankruptcy court judge tell me that the very best part of any CLE presentation is to give some practical tips. So let's talk practically speaking what this looks like if you are the party to a contract counterparty, and your contract counterparty files for bankruptcy. Let's start with what are we looking for, right? How do you get notice of your lease? So as Rachel and Zach both alluded to, the debtors and debtors in possession have a relatively long period of time, frankly, to make a determination if they're going to assume or reject a lease. In most cases, they have all the way until the disclosure statement, which is nearly the end of the bankruptcy case. When they make a decision as to what they're going to do with your lease, depending upon size of the lease and the importance of your lease, you'll get notice through one of two ways. You may get notice if you have a lease that's very important to the debtor. You may get notice through your business contact, where they call you up and you're having regular conversations with them, and you say, what are you going to do with my contract? What are you going to do with my lease? And they may tell you, and then they'll say, and we're going to be filing a motion, because that's how you start this process typically, is by filing a motion. We're going to be filing a motion, and our motion is going to either say, dear court, we'd like to assume this lease. These are the business justifications for it. And here is what we think the cure amount is. That document will be mailed to you at the address for notice under your lease agreement. And there's case law out there that says that's where they're required to notice you as it relates to the contract. If you get a piece of paper that says we're going to assume, it will either be, like I said, a standalone motion, or in the case of a sale, or in the case of a plan, it might just be a big schedule that says, we are anticipating that we are going to seek to assume this list of contracts. So you're looking for a document that says notice of intent to assume or notice of cure claim. If you get that document, it is very, very important that you immediately look at it and determine if you agree with the cure amount. If you don't agree with the cure amount, you then need to either contact your counsel if you have counsel engaged, or your internal office if you've determined this is something that you're not going to use external counsel for. Your internal lawyers need to reach out to debtors counsel and advise them that you disagree. Now, the most protective thing you can do when we're back on our spectrum of most protective versus least protective, the most protective thing you can do if you disagree with the cure amount is to file an objection, because then it's filed with the bankruptcy court. Everybody's aware that you disagree with the amount of the cure claim. If it's a small amount, you think that they're a couple of $1,000s off, but it's not worth engaging outside counsel for you, then you can, I think, send an email to their lawyers and say, I'm registering my, my objection, I disagree. And typically bankruptcy courts will expect that those, we call them informal objections, will also be recorded back to the court and will hopefully be resolved. So that's if you object to the cure amount. What do you do if you object to the actual assumption and assignment of your contract? I will tell you that that is a very, very steep hurdle. The debtors only have to demonstrate business judgment in order to justify the assumption and assignment. So as long as they are seeking to assign it to a party who is creditworthy and they've established the cure amount, absent some what I would call extenuating circumstances, they're trying to assign your contract that contains your IP to one of your competitors. Absent something like that, it's very difficult to stop the assumption and assignment of a contract to a third party. But it is really, really important that everybody in your organization be on the lookout for and understand that they need to send immediately to you, to your general counsel's office or whoever's been tasked with dealing with this, any notices that they receive with respect to assumption and assignment. What do you do if you get a notice that says the debtors have determined to reject your contract? Same thing, that you need to get that notice to the office of your general counsel or whoever's been assigned to track that project quickly. The rejection of the contract oftentimes will trigger the bar date, which is the deadline for you to file a rejection damages claim. If you miss that date and the debtors can establish that they properly served you, it is very difficult for the court to get the court to allow you to file a late file claim. So again, it's important, if from a practical perspective, if you get a notice of rejection, that you look at it carefully to determine what the bar date is. If you look at it and you're like, Sarah, Zach, Rachel, I cannot tell heads or tails what my rejection bar date is, which may be the case, send us an email. One of us will look it up for you. And we're always happy to help. We answer a lot of one-off questions like that. We'll look it up and we'll give you an answer. Now, one thing, and Rachel and I experienced this last year in a really messy healthcare case, that you sometimes will see in connection with assumption and assignment, and you have to be very careful about this, is you will see a debtor that will notice out all of their contracts and they will say, we're going to assume all of them, and every single one of them has a cure amount of 0. I'm willing to bet whatever money is in Zach's wallet right now that that is not actually the case, right? And that they don't have a 0 cure claim for every single one of their contracts. It's just very, very unlikely. What that debtor is doing is they're trying to play a little game of gotcha. And they're trying to say, I sent my notice of assumption to company A, to company B, and to company C, and it said 0 for every single one of them, even though I knew I owed them each $500. I'm making that number up, obviously. And they missed the response deadline. They didn't object to the cure amount. So now when I show up after the bankruptcy case and I say, you need to continue to provide me services, presumably on favorable terms under a pre-petition contract, and the contract counterparty looks at them and says, but you didn't cure my contract, you didn't make me whole, you still owe me $500. The debtor is standing there with a federal court order that says it doesn't matter that I didn't pay you that $500 because I have an order that says I owe you nothing. and you failed to respond to it. In the case that Rachel and I worked on, it was a large healthcare company with a number of hospitals. That's exactly what they did. They noticed every vendor out at zero. They caught, I don't know, Rachel, what, maybe 50% of them that everybody said is zero. And so they all got zero cure claims. And then the debtors took it one step further and they said to these contract counterparties who raised their hand and said, you owe me more money. They said, I understand. I get it. I owe you $500. I owe you $1,000. I owe you whatever it is. I can't pay it. I don't have the money. So you have the choice. You can either agree to a cure claim of $0 or $1 or $2 or something materially less than what I owe. And then we'll assume the contract and I'll continue to do business with you after I exit for bankruptcy. Or you can say no. And if you say no, the net result is that I'm going to move on and I'm going to use a different vendor. So you can see from a practical application, this is an incredibly powerful tool for a debtor and debtor in possession when they're trying to fix some operational issues that they may have.
And just to
Pause
build
there and
on,
see Rachel, go ahead.
yeah. So in that case, there was talking about the plan provided zero recovery in terms of, distributions to general unsecured creditors. So if you didn't agree to a zero cure amount and get that ongoing business relationship, you filed a proof of claim laying out your rejection damages and you didn't get a distribution. So that was a very tricky case where the debtors really used that tool for their benefit and they did exit Chapter 11 with the continuing business.
So that is one area that I just think everybody who's on this call is going to get touched by that likely at some point. Another area that we hear a lot about, and I know we've only got about 10 minutes left, but Zach, can you talk a little bit about avoidance actions and sort of what contract counterparties should be aware of in that context?
Yeah, so avoidance actions, that goes back to the principle that all creditors should be treated equally. So oftentimes in the run up to the bankruptcy, a debtor will make irregular payments to certain creditors. Those creditors or those payments, broadly speaking, are called preferences. The name is suggestive of what it's meant to cover. So in the 90 days prior to bankruptcy, the debtor has the ability to avoid payments that were made to creditors. This is to ensure that some creditors don't receive a higher distribution than other similarly situated creditors. There are a host of defenses to preferences. A lot of it's factual, some of it's legal, but in general, our consistent advice to folks is that if you receive if a company that is in financial distress approaches you, you have a feeling they may be close to bankruptcy, and they're offering to make you a payment in advance of the regular payment schedule or whatever the case may be, you may think, oh, this could be a preference. Do I really want to accept this money? The answer is you should accept the money. It is much easier to deal with preferences after the fact as a non-debtor counterparty because there are, like I said, there's a host of defenses that it may not actually qualify as a preference under the statutory requirements. It may be the case that the debtor doesn't even pursue his preferences. So a company may make preference payments, it goes into bankruptcy, and it could be as a result through structuring that the debtor agreed with its creditors or whatever the outcome was, but it agreed to waive preference actions against creditors. Or it could be that you have a contract with the company and the company assumes your contract through the bankruptcy. There's no longer a preference claim anymore because as we just touched on, a debtor is required to cure all defaults. So it would have had to pay the amounts that it paid you as a preference in any event if it assumes your contract. So the best move is just to take the money. That's the 9/10 of the law is possession phrase. So that's one side of the preference, or that's one side of avoidance actions. The other side is the fraudulent transfers. So starting with actual fraudulent transfers, this is an ancient law, and really what it's meant to do is to stop debtors from taking their assets and shielding them from their creditors. So if a debtor with the actual intent to defraud its creditors moves its asset, does anything that takes its assets or or incurs additional liabilities with the intent to defraud its creditors and keep those assets out of reach. That's what we call an actual fraudulent transfer. I would say these are frequently alleged, but less frequently actually proven because the intent is a high standard. More common is a constructive fraudulent transfer. This is doing away with the fraudulent intent prong, and instead the code asks that you look at, was there reasonably equivalent value given in exchange for the transfer in question? If there was not reasonably equivalent value and the debtor was insolvent when it made the transfer, then that's a constructive fraudulent transfer. Those are factual questions and they can be subject to substantial litigation. So whenever we're counseling clients, we always examine the risk of a transaction, whether it's a financing transaction or a private equity transaction or whatever the case may be. We always look at it through a constructive fraudulent transfer lens and to understand the risks that down the road any transfer could be attacked or challenged in the bankruptcy court. And then if we're involved in the bankruptcy on behalf of official creditors committees or other creditors, I mean, this is a prime investigation area that we look at in terms of, what were the transfers that the debtors made prior to the bankruptcy? Were they done on fair terms? Did the debtor receive the fair value for those transfers? And if not, do we have a legitimate constructive fraudulent transfer claim? So these are all issues that percolate in the background of bankruptcies and often come to the forefront in certain bankruptcies, but they're all issues and vocabulary that we think, all folks involved in a distressed company situation should be well aware of, because you never know what kind of litigation you could find yourself in.
Yeah, and maybe just one thing to add to what Zach was saying, one of the things that I always tell everybody, like the words fraudulent transfer sound awful, right? Because they have the words fraud in them and nobody ever wants to be associated with something that says the word fraud. But fraudulent transfer, I mean, if you've got actual fraud and you move something around with the actual intent to defraud creditors, yes, that's clearly bad. That's not usually what we see. Usually what we see is a constructive fraudulent transfer where somebody got a deal that was just maybe a little bit too good, or they were giving value that was, when you looked at it as a package and you looked at the monetary value, the non-monetary value, and the prospective potential value that was going into it, and the fact that you were buying the company a lifeline, all of those things taken together at the time that the transaction occurred felt like they were getting reasonable equivalent value. The problem is the look back period for fraudulent transfer in particular is very long. We're looking back 2 years, and under Texas state law, you can look back even longer than that. And everybody has the benefit of hindsight. They know exactly how the transaction has fallen out. If we're finding ourselves in a situation where we're evaluating a fraudulent transfer claim, maybe the transaction feels like it didn't go as well as it should. And so, I say that because I think, fraudulent transfer, it sounds very bad. Like I said, it does not necessarily mean that you did something wrong. It just means maybe that the pieces didn't fall together in the way that you anticipated. And now you've got a creditors committee or another party who's trying to create some leverage so that they can get a recovery. So we have only got just a few minutes left. If we've got any questions, I would encourage people to throw those in the chat. And in the meantime, maybe Zach, if you wanted to talk for a little bit, I mentioned creditors committees and their investigatory power. Do you want to talk for maybe just a minute on that? We'll see if anybody has any questions to add as well.
Yeah, sure. So as I mentioned at the top, the bankruptcy code provides that official committees can be formed in the bankruptcy, and that just means that they're statutory creatures. And the nice thing about the statute is that it also provides for payment of the professionals. And the way that this typically works is that the U.S. trustee is tasked with forming the official committee. So depending on the jurisdiction, the U.S. trustee will receive a list of the creditors, of the unsecured creditors of the bankrupt company. The trustee will look at that list and send mailers or emails, or however the trustee in that district communicates with creditors. It'll send out notices asking, are you interested in serving on the official committee? When you get that piece of paper, if you're interested, send it back. The trustee will take a look at the responses. It may talk to the debtor, just get the debtor's views on who the debtor thinks would be good representatives for the official committee. And the trustee will form the committee based on the responses. I mean, the trustee generally tries to find a diverse mix of creditors. So it is rarely the case that an official committee is comprised entirely of, say, the bond trustees for funded debt. Typically there may be one or two bond trustees, but then, in addition to the bond trustee, there may be a litigation judgment creditor. There may be trade creditors or other critical vendors to the enterprise. Landlords are very commonly on official committees. And these creditors collectively form the official committee, and they act as a single fiduciary body. So they hire professionals, both lawyers and financial advisors, to advise them as to the bankruptcy cases. And because of their role in the Chapter 11 cases, they are quite influential in how things develop and ensuring that unsecured creditor interests are well represented during the bankruptcy. Because oftentimes it's usually the case, of course, the debtor will have its paid professionals. Secured creditors benefit from the fact of their security, and they have leverage because of that. So oftentimes unsecured creditors face less representation, but for the official committee, so that they can play an important role.
So with that, as I said, we like to leave you guys with the practical. And so we're going to do just a little round of practical tips in interacting, particularly when we're in a market of financial distress. My practical tip is check your mail. Check your mail, check it early, check it often. It's super easy because depending upon where you're at in the creditor stack, may find yourself getting a lot of mail from the bankruptcy court. Don't just throw it all in a pile and assume that you can deal with it in a couple of months, because you may miss an important deadline.
It's my tip is related to the bar date, and it's a date by which a creditor needs to file its claim in order for it to be valid and count against the debtor. Typically, you'll see a debtor will file a motion to set a bar date, but in certain districts, including in Houston, the Southern District of Texas, there's an automatically set bar date at 90 days. So you'll be waiting for this motion and it'll never come, and the 9 days will pass. So don't forget to look at local rules, have your counsel look at the local rules to see if there's a default bar date by which you need to file your.
Mine would probably be, don't assume you know the answer. And this goes for me as well. Bankruptcy is not terribly complicated, but there's a lot of nuances involved. And, what you think might be the right answer you may have stumbled upon the one area of the law. There's a nuance you haven't seen before. The rejection is an easy example, where oftentimes clients think of that as termination, but there's more to it than just a termination. But always think about the issues, and always don't be afraid to ask folks who practice in this area.
With that, thank you so much for having us.